Alissa, Sharon?
I have prepared some comments today, and I'm going to try to stick to those comments, regardless of how tempting it is to address the multiple defamatory statements that have been made about me in the last, 30 minutes. Members of the board, I want to thank you for the opportunity to speak this morning. My name is Dr. Alissa Sharon. I've been licensed by the board since 2006. I've been conducting family law evaluations since 2005. And have been court appointed in over 300 such evaluations, performing both custody and forensic psychological evaluations. However, it is with great sadness that I announce that effective February 1st of this year, I am no longer accepting any more court appointments. I love what I do. You can see how incredibly inappropriate all of this is. I hope and I encourage everyone to come up here and talk. I love what I do. However, the harassment, defamation of my character and professionalism, and death threats have made this job untenable. All you have to do is look up my name on Yelp to see the dozens and dozens of horrible things that are said about me. Yelp does not allow these reviews to be deleted, and I'm not able to respond to them due to my own ethical obligations of confidentiality. Similar to what's happening here today, while people have come up and said these multiple things about me, I can tell you that none of them are true, but I cannot tell you anything more about them because I am under a confidentiality rule not to speak about them. And Yelp is just one social media platform. I've recently had to hire a reputation management company costing thousands of dollars in order to clean up this information so that I can transition into a different area of practice. I have been told that I was going to be taken out by somebody in this room, actually. And one Twitter user that I have never even met said someone, excuse my language, needs to teach that cunt a lesson after reading the false statements made about me by a former examinee. I am not alone. Some of my colleagues have small children and have had to lobby tirelessly and unsuccessfully to have their personal information taken off the internet in order to keep their families safe. In December of 2017, a Travis County family law litigant who was evaluated by a colleague murdered his own daughter and took his own life. Just last summer, a man who had vowed to punish those individuals involved in his custody litigation when they least expected it, murdered 6 people a full 7 years after his family law litigation had concluded, including the custody evaluator. None of this is anything that you all can help us with. However, my colleagues and I are well aware that one of the ways these examinees harass us is through frivolous, expensive, and time-consuming board complaints, with the sole intent to threaten our livelihoods that support us and our families. As part of my career, I was a tenured professor at the University of Texas in Austin for 13 years. As part of that role, I taught the ethics course in our APA accredited counseling PhD program every fall semester. I am well aware that the board does not exist to protect me. It exists to protect the public, and rightfully so. However, there are times when protecting the public and protecting your licensees intersect. I have heard some professionals talk about soft-pedaling their recommendations to the court in order to avoid board complaints in situations like I have going on in my life. This is a disservice to the children we've been asked to protect. Others like me are choosing to quit or significantly reduce their practices, leaving an already burdened system with even fewer competent professionals. The passage of the Texas Family Code Section 107, a law I testified to the legislature in support of, makes great strides in opening up the field to master's level practitioners to address this shortage. But the reality is psychologists have been doing this for decades. Our advanced degrees, our extensive training, and our research and psychometric experience and expertise make us the professionals the courts listen to the most. And not only are we fleeing in droves, as it stands now, we do not even want to take on the liability risk of training the next generation of custody evaluators to take our place. It is unfair for me to stand here, though, and complain about a problem without providing any solutions. Solutions to this problem are tricky because they cannot infringe on our citizens' constitutional rights to due process or free speech. But the solutions are not impossible. A number of states have already enacted provisions that provide limited immunity against board complaints provided the psychologist acted in good faith, as defined by the standards recommended in the APA guidelines for child custody evaluations. I have a few ideas for you. Number one, you could charge higher dues for those of us who take court appointments. These funds could be used to compensate a former custody evaluator who serves on the board and whose sole responsibility would be to gatekeep the intent of the complainant and decide whether or not it should go forward. Similar to the Texas Bar Association complaints or judicial misconduct complaints, not every complaint would warrant the professional's response and could be dismissed before the psychologist was aware a complaint had been filed. In addition to this, you could also require, I think someone talked about postdoctoral training and how important that was to him, and I agree with that actually. But you could require additional ethical training to be granted sort of this automatic passage into this gatekeeping protection function, so that you know not just that I did a custody evaluation and you all should, you know, put me through this gatekeeper, but I've done this training that the board says is important to do in order to do these custody evaluations, and then you would be entitled to that sort of gatekeeping function. Number two, limiting the time frame in which complaints will be accepted or pursued. For example, only permitting complaints once litigation has concluded, requiring a cooling off period of 90 days following settlement or final trial, and rejecting complaints for cases that have litigated 5 years or more prior. Number three, broadening the scope of information required of a complainant in order to file a complaint. For example, requiring complainants to include a copy of their court order that ordered the evaluation, a copy of the report, the entire report, a copy of the trial transcript, a copy of their final order, and requiring the complainant to allow the board to solicit information from the opposing party or the attorneys or the judge who presided over the case. This would help in instances where complainants cherry-pick the information provided to the board rather than give the board complete objective information. And I think with this particular one, it's important to remind everybody that these examinees only come to custody evaluators when the judge in the court does not know what to do with them because their behavior is so problematic. And of all the people that go through divorce court, family law court, only less than 1% of the people that go through that process end up in an office like mine. I don't seek them out. They are ordered to come to me because the judge does not know what to do. And if they do not want the expense of someone like me or a trial or their lawyers or what have you, they do have the choice to stop whatever behavior that they're engaging in that concerns the court and enter into some kind of settlement that's reasonable for their children. That is always an option available to these individuals. Number four, granting immunity to psychologists who are court-ordered except in cases of egregious behavior such as sexually inappropriate behavior, financial dishonesty, or child abuse. Court-appointed professionals are one of many possible witnesses and are subject to cross-examination and Daubert admissibility standards. So these legal procedures are, in a sense, built-in safeguards to many of the alleged offenses found in frivolous complaints. For example, something like alleged bias would be fully vetted through the rules of civil procedure. As such, considering more blanket immunity makes sense given that complainants will either, number one, have had a final trial in which both sides are able to present all evidence to a judge, or number two, the parties have settled, in which case the complainant has made an agreement with the advice of counsel and informed consent to the terms that become part of the final order. I'm almost finished. Number five, barring complaints from people who did not receive direct services from the psychologist. For example, a parent who lost custody of their children because the court found the parent to be alienating the children from the other parent may go about pursuing complaints against any professional who writes or testifies about parental alienation, even if that professional had no direct connection to their case. These complaints are access to grind, not legitimate threats to the public. In addition, I urge the board members to consider two other issues as you contemplate possible changes to the code. First, not all court appointments are for custody evaluations. Psychologists are also court appointed to do forensic psychological evaluations, guardian ad litem work, and even individual child and family therapy. Each of these court appointments need the aforementioned protections for the same reasons as custody evaluators. Second, for the safety of the licensees, I urge you to pass legislation that would allow those of us accepting court appointments to request confidentiality under Tax Code Section 25.025. Currently, 21 different categories are covered under this provision, including employees of the Attorney General, judges, probation officers, forensic analysts employed by the state, police officers, and victims of stalking or family violence. As an arm of the court, the inclusion of court-appointed professionals under this provision would be consistent with the provision's mission to protect professionals at risk of retaliation for the work they do by restricting public access to our home addresses. This protection would contribute to a safer working environment, ultimately leading to less burnout, longer careers, and more access to services for the public that you serve. Thank you so much for your time this morning.
And